The next item is in reference to 0605 and the Overture Advocate from the Presbytery of Newark.
Mr. Moderator, ladies and gentlemen, I'm Gordon Fish from Montclair, New Jersey, on behalf of the Presbytery of Newark. Newark Presbytery is among the most ethnically and theologically, racially diverse on virtually every category that one could think of. We unanimously ask you to do three things: dismiss the task force with thanks, refer NFOG to the presbyteries for further study and discernment, and trust the presbyteries to propose a future course of action. I want to be very specific and focus all my attention this afternoon on the effect of NFOG on the church court system. Four big topics. Foundations, the superconstitution. You've already heard some discussion of that. The authority of the GAPJC, the weakening of protections under the church court system, and the chaos that will ensue. Under the existing form of government, the church courts have established unquestioningly that the Constitution must be read as a whole to affirm all of its provisions. Every minister here who studies Scripture knows that principle. It's the same principle that goes into the study of Scripture. Interpret the whole. Under the NFOG, we have a new foundations section. The question is, are all provisions equal, but some more equal than others? And would the new F section be given more weight than F? I would refer you both to the presentation of the task force today and to the first paragraph of the rationale that's on page 3 to indicate that the view we are being given is yes. What's the effect? The effect in the church court system is that generic statements in the F section become the hermeneutical lens for reading specifics in the G section. For example, for starters, ordination standards would be only the tip of the iceberg. Would the provisions in the F section that rightfully speak to inclusiveness be viewed now, instead of reading them together and on an unequal par, in which the F provisions trump the specifics of G? It would reopen all sorts of questions, and there would likely be endless wrangling in the PJC and a loss of trust. As proposed, the NFOG would strip the GAPJC of its power to make binding interpretations of the Constitution. Every PJC would start from scratch and stand on its own. There would be no precedential value of previous decision. There would be no controlling legal effect. The court system in the secular world would grind to a screeching halt if that were to happen. The same would happen in the church court system. Neither the GA nor the ACC is well suited to give detailed authoritative interpretations, and countless centuries of experience in both the church courts and in secular courts prove the value of the back and forth of well-crafted legal argument. Each side gets to make its best case, and wise persons weigh those on an equal basis. The proposed amendments are only a partial fix. They take care of the GAPJC problem, but they still leave the question of whether the GAPJC precedents would control future actions. The weakening of church law provisions. Under the new form of government, unjust governing body decisions or council decisions based on handbooks would not be challengeable in the PJC system. The court has ruled very clearly in a case a couple of years ago that a presbytery's failure to follow its internal policy is not constitutional error and therefore cannot be addressed by a PJC. In addition, anything that is based on permissive language will be presumed to be correct and cannot therefore, in a practical sense, be challenged. There are other problems. If I were a minister, I'd be scared out of my gourd that I could be removed from my office without even a congregational meeting being held. How many more unintended consequences have we not discovered yet? There's chaos in the PJC ahead of us. The workload is heavy. The applicability of all existing GA and GAPJC interpretations and decisions becomes uncertain.
Excuse me, Gordon.
Every one of them can be overtaken.